Hi, my name is Ashley, and I'll be presenting on prior restraint involving high school students. In Mountain View High School in California, two student journalists, a part of a journalist class, were writing a school newspaper article on the sexual harassment happening at their school. And before this article was published, the principal heard of the article being written and ended up threatening and bullying the students into self censoring that article to take out graphic details from other students' accounts. After that article was presented and published in the school newspaper with the redacted information, the principal took the teacher out of the class. They took the student advisor from their position, and then they canceled the class for future semesters. And in September of 23, the attorney representing all three of those parties, the students and the teacher, sent a letter to the superintendent, the school district, and the principal asking for acknowledgement of the principal's actions, as well as reinstatement of the teacher and the class. With zero response in February of 24, they filed a lawsuit against the principal and the school district, not for any monetary values, but instead for reinstatement. The ethical issues that are brought forward with this case is the journalism code of ethics. The students, as journalists, have a right to seek the truth and report it. They have a right to minimize harm, which is what they did by redacting those very specific and graphic details of students' interactions with this one other student. They also have a moral responsibility to be transparent about these problems happening in their school, and they have a right to report that. It is unethical for any journalist, student, or adult to not seek First Amendment rights and stand up for it. Now, for this court case, I think the two Supreme Court decisions will be brought forward is the Hazelwood versus Kohlmeyer. The Supreme Court sided with the school because the classroom is a limited public forum, it's not open, so they are subject to censorship of inappropriate topics. But the Supreme Court sided with the students in the Tinker versus Des Moines case because disruption is not a case for censorship, and the students have a right to the First Amendment, and that does not leave the doors when they enter school grounds. Now, the principal is being accused of breaking California educational code for not allowing the newspaper to be in the school. Not only that, she is facing the charge of retaliation, which is against a labor code. Now, this is because she took away the class as well as the teacher from that class. Now, during the trial, during the hearing, I think that the evidence that will be brought forward is that classroom considered a limited or open public forum? I think that they'll bring forward that the First Amendment rights don't leave when you enter the classroom or enter school grounds at all, such as those two Supreme Court cases. I do also think that they'll bring the evidence forward for retaliation. The teacher, the student, and the class all being taken away. And I also think that ethically and a just outcome would look like the class being reinstated, the retaliation charges being kept and acknowledged, and the students will have that right to publish information without censorship, at least none that would cause harm. Now, what I think will actually happen in this case and the legal outcome would be that they might define what inappropriate topics mean for high school students, because sexual harassment is a tough subject, but it was happening at the school. I also think that due to the evidence being brought forward that I have read in these articles, that retaliation would be acknowledged. These are my works cited.